Welcome, everyone, and good afternoon. Welcome to Division 2 of the Colorado Court of Appeals. It is October 17th. We have two cases on our afternoon docket. We have a full courtroom. I will go over some, welcome, everybody. I will go over some basic procedural kind of protocols. I'm sure that most of you are familiar, of the council are familiar with these, but I'll just go quickly. First of all, I'll introduce myself. I'm Judge Pawar. To my right is Judge Furman. To my left is Judge Fox. Please remember that each of you have 15 minutes on either side. And for appellant's counsel, if you would like to reserve any time for rebuttal, it'll be up to you to watch the clock and stop yourself. We can't promise that if you're not in the middle of if you're in the middle of a question, we might ask you to complete it before you just sit down. And if there are any identifying names or other information that you would like to keep confidential, please be mindful of doing that, because we are live streaming our oral arguments and everything is archived, and so it will be in the public atmosphere, as they say. As you approach the podium, there's also a toggle switch on the lower right side, so it can raise and lower that podium so that it can bring that microphone to your speaking level, because again, we're being recorded. We'd like to make sure we pick up all of the arguments on the microphone. And towards that end, also, we ask that you stay close to the microphone instead of meandering outside the podium. Any questions? No, great, thanks. Seeing none, we will call the first case, and that is Gebert versus Sears Roebuck. So counsel for appellant, when you are ready to proceed, please approach and do so.
Thank you, Judge Pawar. May it please the court. Fred Yarger, registration number 39479 for appellant Sears. Across jurisdictions, the universal rule is that if a party denies an allegation in a court document, that denial is not evidence and cannot be introduced at trial. That's because a denial is not a fact. It's a litigation position adopted by a party, usually on the advice of counsel, and it's therefore irrelevant to the issues that the jury has to decide, unless, of course, the party's litigation conduct itself is at issue, which is not the case in a personal injury matter. Here, the trial court acknowledged that the evidence at issue, Sears' denial of allegations in the complaint and a denial in response to a request for admission, was, quote, a collateral issue, not an issue for the jury, and unnecessary, and yet allowed that evidence before the jury, and in fact allowed a particular witness to be called specifically to be questioned about denials that Sears had raised in response to the complaint and request for admission.
Sorry.
Yes, please, Your Honor.
When you say that the trial court found that these issues were collateral and not at issue, can you give me the context in terms of the timing of when that happened, and be as specific as possible? Because I'm sure you'll get to this. My question is around, the definitiveness of the ruling, and that came later, as it was my sense, as opposed to as part of like a pretrial motion. And so can you put those in kind of chronological and context?
Sure, I'm happy to. And the record on this actually is kind of throughout the transcript because it was raised so many times. So day one of trial, before the jury was called, before voir dire and selection, counsel for Sears raised this particular issue, and specifically with respect to the witness that was subpoenaed to testify to this Sears' denials of the allegation, Mr. Kearns. That was the time at which Judge Volt said, I don't think it's that important to anybody, but I'll let you argue it if you want to. It's your case. So that's one point where she said it wasn't relevant.
Okay, so did she say it wasn't relevant, or did she say as to relevancy, I will have to wait to hear the question to determine it as we go along?
Right. The one thing she made clear in that ruling was that Mr. Kearns would be subpoenaed and would take the stand. So we know for sure at that point, even though Sears' objection was to calling Mr. Kearns at all, because Sears' position was he really had nothing relevant to add to the case given Sears' acceptance of liability and the stipulations read to the jury, we know that the ruling at that point was, yes, he's going to take the stand. She did say, I'm going to reserve relevance objections for the stand Obviously that's the case with every witness. Every time they take the stand, there might be other relevance objections. On day 2, Mr. Kearns was called remotely. And before he took the stand, and I'd like to give you the citations, that's day 2 of the transcript. I think it's 67 and 68. Sears renewed its objection, said, just to be clear, we object to him testifying because of relevance and Rule 403. And they talked specifically about the timeline, and he said, Sears' counsel said, he's going to be allowed to ask questions about the timeline, question mark, to the judge, and the judge ruled, yes, correct. So again, that was a second time where definitively the judge said, yes, he'll be taking the stand, he'll be able to be asked about these subjects. And then, of course, once Mr. Kearns did take the stand, I think it was day 4 when he was there in person, there were contemporaneous objections. Judge Volson, to answer your question, Judge Pawar, sort of towards the end, I think, grew frustrated by the amount of questioning on the subject, which she didn't find to be relevant. That's when she called it super collateral and not an issue for the jury. And then in post-trial motions, she said again, this was not an issue that was relevant or for the jury's consideration, given that there was an admission of liability and vicarious liability. So in terms of preservation, it was before trial, day 1, it was day 2, and then it was when the witness was on the stand.
Counsel, so even if we agree with you that, this was in fact irrelevant and that, maybe the trial court should have kept all of that out, I don't understand what the prejudice is here, especially given that liability was not an issue. So it's not like, Sears got found responsible because of this testimony. Sears admitted that it was responsible.
Right. And the problem with the testimony, and this is reflected in the case law, and I think it played out in this record, is that it shifts the jury's focus from the issues that were before the jury, which was, in this case, causation and damages, into a collateral issue about litigation positions that Sears took very early in the case, and the time it took between that time and when it decided to admit liability about six weeks before trial. And what this court said in Parsons, for example, a little different context, but it said this kind of evidence about a party's litigation conduct can lead to, quote, unfair prejudice, misleading the jury, and confusing the issues. And so here, the problem was, and we know this was an important sort of theme of plaintiff's case because it was the first argument they raised during closing argument to the jury. The focus was taken away from questions of causation and damages and focused on Sears's decision, in their words, to, quote, not accept responsibility and deny responsibility, and, quote, there's no reasonable basis for that. Of course, those were all issues that really were before the court on the motion for sanctions. And that's the solution to this kind of an issue when a party doesn't reasonably admit a fact or engages in any other kind of conduct with respect to a pleading or a discovery document. There are all kinds of remedies in the discovery rules and the rules of civil procedure that address that conduct. And here the judge said there really was a reasonable basis for Sears to deny liability. Sanctions wouldn't be imposed. And that's exactly the situation where the courts say the solution is sanctions to the extent that they're necessary. The solution is not to inject these collateral issues focusing on a party's litigation decisions to the jury, which really shouldn't be, asked to decide not only causation damages, but whether it was, quote unquote, reasonable for a party to deny liability early in the case. So I think that was the error, that it was a single witness called specifically for the purpose and only for the purpose of addressing this collateral issue. And I know, plaintiff's position is that it was a small portion of the record. Well, it was an entire witness. It went on for about 20 pages of the transcript. And we know that this was a major theme of plaintiff's case because it was the very first argument that plaintiff's counsel made to the jury in closing. And given the case law and given the sort of uniform rule that this is irrelevant information and it's not an issue for the jury, and according to Parsons, for example, it does cause prejudice and it confuses the issues, that's our harmless error argument.
So when you say that it confuses the issues, I'm a little unclear from the briefing, and I understand from your argument now that there's a difference between admission of liability and admission of causation. And so what you're saying is the prejudice related to the evidence regarding causation, not liability?
Well, there's a little bit of a semantic debate about whether we admitted liability or admitted what plaintiffs are calling negligence. What we admitted was that the Sears technician did in fact miswire the stove. We admitted that Sears was responsible for that technician's conduct. We admitted that the shock event, was caused by that miswiring. What we did not admit is medical causation or damages. So I don't want to, there's a semantic debate about whether we admitted liability or facts that established at least one element of the case versus the entire case. We've cited some cases where this court has used liability and negligence kind of interchangeably, so that's not the issue. I think our concern is, in a negligence case, you've got injury, damages, causation, duty. Whether or not a party admits or denies a fact during the course of litigation before trial isn't an issue that the jury has to decide. Whether the party should have admitted that earlier, whether the party is sufficiently culpable or has, acknowledged liability, that's not an issue for the jury, because the jury's there to decide whether in fact an event occurred, whether it was caused by particular conduct, and what the amount of damages is. It's really not a culpability analysis.
So credibility doesn't play into that at any point?
Right. So this gets into the line of case law that talks about whether in fact a denial and then a later admission or a denial can be inconsistent. And what the case law says is it can't be, because a denial really isn't a statement of fact. You can deny an allegation for a number of reasons. Here, it was because the complaint was filed and then the RFAs were issued not too long after the complaint, within a few months of each other, before discovery was complete. Sears didn't have all the facts, and it's certainly a party's prerogative to decide, I'm going to deny an allegation at this time because investigation, discovery is not completed. Of course, over the course of discovery, a party can change that position and decide whether or not I agree with you, whether or not I do think this allegation is true. I'm going to admit that fact for trial for maybe purposes of streamlining, for a whole host of reasons. But the point of the point of fact is, a denial is not a statement of fact. It's a legal position, and I think Gutierrez from the Supreme Court of Massachusetts says the purpose is simply to, quote, narrow the issues for trial by identifying those issues for which proof will be necessary. It's not a statement of fact. So that's why the case that follows Consalves and Gutierrez itself, they say it's not really a question of inconsistency, because when you deny an allegation, that's not a statement of fact. And I think that leads into the plaintiffs are making kind of a hearsay-based argument. We're not talking about hearsay here. We're talking about the previous step, which is relevance. Is this evidence at all relevant to the issues the jury has to decide? Our position is it's not, and the case law, I think, bears that out. I notice I'm into 4 minutes. I would like to reserve time, particularly for the cross-appeal issues, if I need to address those.
Thank you, Your Honor.
Thank you, Your Honor.
Counsel for Applee, when you are ready.
Thank you, Your Honor. May it please the court, Counsel Robert Fishman on behalf of Ms. Gebert. I'm here to answer your questions, so please interrupt me if I start about 4 steps into this case. Can always back up if you want me to address the evidentiary questions itself or objections related to Mr. Kearns' testimony, the definitiveness of the trial court's pretrial ruling, all of those sorts of matters. I want to jump ahead because I think you can accept as correct almost everything that Mr. Yarger just told you, and Sears's appeal fails for 2 reasons. Number 1, putting aside the question of timely objections to Kearns' testimony, their appeal focuses on the prejudice resulting from the closing argument. And there's no question that there was no objection to the closing argument. There's not really any question that under Colorado law, you cannot bring a claim seeking a new trial based on an improper closing argument if you have not objected to it.
So, sorry.
Please.
To split that, I guess. If the admission was error, then it's a different argument, or it's a less It's a more diluted argument regarding prejudice because we can't consider closing argument even though the jury heard the testimony.
Yeah, I think it's a little bit of both, because the argument on appeal is reversible error results from the prejudice of closing. There is no independent argument made on appeal that the admission of the evidence in and of itself warrants reversal. That's number one. Number two, the objectionable aspects of those two things are entirely different. The objection to Kearns's testimony is relevance for the reasons you just talked about. The objection to the closing argument is this is designed to inflame the jury and encourage it to punish us. Entirely different objections, entirely different complaints that should be brought to the attention of the trial court.
Well, doesn't that contemplate 403? I mean, like your opposing counsel indicated that the objection was made under relevance in 401 and 403.
Well, I'm not sure I understand the question. My point is, when plaintiff's counsel is giving the closing argument saying they never accepted responsibility, and Sears's counsel is thinking he's trying to punish us, he's trying to get the jury outraged and punish us. The objection would not be to stand up and say objection relevance. I mean, that objection was made, the evidence came in, they lost. The objection would be they're trying to inflame the jury and impassion them and punish us. This is not a case about punitive damages, and the court would not have said, presumably, right, I think it's relevant. Right. The court would have said to the jury, disregard counsel's comments.
So there was no objection to the closing argument statement. So going back, if we were to, assuming, let's just take the assumption, if we were to agree that there was error in the admission of the testimony, then we have to consider whether that error was harmless or not. And are you suggesting that because there wasn't an objection at closing argument, we can't consider that when we look at how the improperly admitted evidence impacted the trial?
That's absolutely what I'm suggesting. And the reason for that is, again, because Sears has not even attempted to show reversible error based on the admission of the evidence itself. The argument is the way the evidence was exploited in closing argument and the way the lawyer tried to encourage the jury to punish us. So the error is an evidentiary one, relevant based at trial. The prejudice, the real harm, the really objectionable thing that results, in their view, in reversal, is the closing argument. And in the absence of an objection, it's been waived. The court should not consider it. And we cite cases for the general proposition, Colorado cases, that if you don't object to a closing argument that you're using as the basis to try to obtain a new trial, it's been waived. And we cite to cases that say that's true, even when the argument is based on evidence that you did object to at trial. It's exactly this situation. And we cite 4 Colorado cases for those propositions. There are dozens of others. Sears cites 2 cases from other jurisdictions to say you don't have to object to a closing under these circumstances. And neither one of them are close to this case. The Moody case from Oklahoma is a case of attorney misconduct. And the court says in cases of attorney misconduct, prolific attorney misconduct, we have the discretion to consider instances of misconduct, even if there wasn't a contemporaneous objection. Has nothing to do with this case. Collins is a case from Pennsylvania, 2007, I think. There, the argument was a lay witness was permitted to testify as an expert and seeking reversal for that reason. And the appellee said, the argument's been waived because I made reference to that evidence in closing and there was no objection. But the difference there is the appellant was not seeking reversal because of the closing argument. The appellant was seeking reversal based solely on the admission of evidence. And the court in that case reversed, saying the evidence was prejudicial, and the court said nothing about the impact of closing argument. So the only authority they have to excuse their failure to object really has nothing to do with this case. The second independent reason, and again, jumping forward, this court, I think, can easily consider both the evidentiary aspect of their claim and the closing argument aspect of their claim. And they still have not proven reversible error. They say, well, it must have been important because it was the first argument raised in closing. It's 30 lines from a 21-page closing argument. The argument was made, in their briefs, they talk about it as the centerpiece of our case. It's 8 pages of testimony in a 1,200-page transcript. It's 30 lines of closing argument. If it was as important as Sears would have you believe, you would think the lawyers might have returned to the theme in their rebuttal closing when they got the last word. But counsel didn't say anything about Kearns' testimony and punishing Sears in the rebuttal. It was a minuscule part of this trial when viewed in its totality.
So one of the questions I had for appellant's counsel was about the question around causation and causation of the damages versus, well, that was part of it. My question for you, bear with me. You're challenging the trial court's reduction of the damages. If part of appellant's argument of the prejudice is the jury was successfully inflamed and therefore rendered a larger verdict, would that verdict then, or would that prejudice be mitigated so that it would be harmless error by that statutory cap?
That's an interesting question.
I'm just glad you understood it. Thank you.
Yeah, I did understand. It's an interesting question, and frankly, I don't know the answer to it. But, to be perfectly candid, it's not an argument we have made. It's not an argument Sears made, and I think in fairness to Sears, their position would be, we would have won this case if it weren't for Kearns' testimony. We're not quibbling over $2 million versus $400,000. So I don't think you can use the size, the reduction of the verdict as a way to say there was no actual prejudice. The flip side, and the argument we have made, is there's absolutely no reason to think the $2 million verdict before its reduction was the result of prejudice whatsoever. And again, putting aside questions of waiver, the district court, in the best position to assess these sort of claims, having presided over the trial, said pretty clearly in the post-trial order, you don't get a new trial when you don't object during closing argument, and you're not entitled to a new trial when you have failed to show that a jury's verdict is the result of prejudice and bias. It's what the court said in its legal analysis. It's pretty clear, to me at least. I think their reading of the court's order is quite unfair, pretty clear what the court meant. In addition, you have the fact that they cross-examined Mr. Kearns on this denial of the request for admission and subsequent admission. And his rationale was entirely benign. I mean, the long and short of it is he said, our employee lied to us under oath. Mr. Childs said he had nothing to do with this. We did a diligent investigation, and lo and behold, we figured out, as they say, that was not accurate, right? Mr. Childs was lying, and he was lying under oath. And as soon as we figured that out, we admitted liability. So, I mean, I think even if you could say under this general case law about requests for admissions, it can be prejudicial, it can be damaging, they had, a pretty compelling rationale and explanation for it. Now, they say in the reply brief, well, you can't point to stuff like that. You can't point to what we did with this evidence as anything that mitigates prejudice. And it is, Pennington is the case they cite. Also a completely different situation. You have cases where prejudicial evidence is introduced, and the non-proponent, the person objecting to the evidence, elicits more of it, and the claim on appeal often is invited error. You brought in some of this evidence yourself, you can't complain about it now. That's not our position. We're not saying invited error. We're saying you did a pretty effective job explaining this evidence. We're not sort of blaming you for it. We're just saying you undid the damage. And that has to be factored into a reversible error analysis. I do want to discuss quickly, because it's such a often repeated theme in their briefs, Dr. Yarnell testimony about the paucity of objective evidence of this traumatic brain injury. I think Sears presents that as sort of a smoking gun. Ms. Gebbert's own treating neurologist acknowledges a paucity of objective evidence to support his diagnosis. Really, nothing could be further from the truth. Dr. Yarnell said, in medicine, in neurology, 100% objectivity, it doesn't really exist. And he proceeded to testify for almost 20 pages about his differential diagnosis, all the things he considered and ruled out as the cause of these injuries, one after the other, based on test after test after test. And his differential diagnosis was the electric shock was the cause of injuries in this case. Now, they can denigrate objective findings all they want and the lack of them, but the fact of the matter is differential diagnosis is a well-accepted method of determining causation in medicine, and the law recognizes it as such. So the fact that our best, most compelling evidence of causation is not objective, but rather the result of a differential diagnosis, is not anything that indicates a weakness in our case. It's a reflection of medicine. It's a reflection of the law. Added to that, you have some pretty compelling circumstantial evidence that Ms. Gebbert's injuries were caused by the electric shock, namely the testimony of her friends, sister, and her own testimony, saying, I never had any of these symptoms until I was electrocuted. Now, there again, Sears can say, well, you're all mistaken, you have to be wrong, or maybe you're all lying. That's a credibility question, and clearly it's one that the jury did not side with Sears on. I think if there are no additional questions, I'll relinquish my 40 seconds.
Thank you, counsel.
Thanks.
Thank you, Your Honor. I just want to go through a couple of points that my friend made during his argument. I think there's a misunderstanding about how we kind of conceive of the objection and then the error. We believe that the error here was the admission of evidence, of really, frankly, calling a witness whose sole purpose was to testify to this particular category of evidence. The closing argument, and I think we say this most clearly, I think it's page 27 of our answer reply brief, the closing argument was problematic because it commented on and focused on erroneously admitted evidence that, of course, we objected to on various grounds. So they're right, we didn't object during closing argument because in our view, the damage had already been done. We'd raised this with the court first day of trial, second day of trial, and while Mr. Kearns was on the stand, third day of trial.
Counsel,
yes.
I mean, isn't this the very type of testimony that should have been addressed well in advance of trial via motion in limine to alert the court, to its duty to to make sure that it properly evaluated all of your authorities and made a thoughtful decision about its admission.
Sure, and this was raised with Judge Scipione in the pretrial conference before Judge Volz rotated on. And that was after the in limine deadline. And I think the parties asked him how he'd prefer to raise it. I don't know exactly how it all landed, but it was raised before the jury was even seated. And it was raised at least a day in advance of Mr. Kearns taking the stand. So I agree with you. This should have been raised, and it was raised before Mr. Kearns took the stand fairly well in advance. And it was raised repeatedly. But just in response to plaintiff's argument, the prejudice is demonstrated by the fact that this was a significant witness that was used as sort of the first message to the jury. And I think that's the concern that we have here, and that's why a lot of the cases say, look, the only reason you introduce this evidence is because it puts the defendant in a bad light, or the party. It could be the defendant, it could be the plaintiff. Both parties can certainly be in a position to deny a request for admission on issues that the jury doesn't have before it. And that was the problem with this testimony. I do want to mention, they did cite a number of cases where there were failure object during closing from Colorado. None of those cases, not one of them, involved evidence that was objected to previously during trial, and then closing argument that commented on evidence that the judge let in. So this isn't that situation. I think we do have preservation here because it was objected to in a timely way. The court had every opportunity to address the issue, allowed the evidence in, and then of course that's your job as a lawyer. You stand up and you comment on the evidence before the jury, and that's what this plaintiff's counsel did. The problem was the evidence shouldn't have come in the first place. And my final point is there's a difference between the sort of excessive damages argument that we made during post-trial and the argument we're making here that was preserved through the contemporaneous and pretrial objections. The objection here is there's this class of evidence that the case law makes clear is not relevant. And it does, in fact, focus the jury on issues that they aren't charged to decide. And the question here is whether the introduction of that evidence through a witness whose sole reason to be at that trial was to testify to this issue, and then it was commented on in closing. So there are two different arguments, and I don't think the judge below really addressed this separate issue, and that's, of course, why we're bringing it up here. And I see my time is up. Thank you very much.
Thank you, counsel. Thanks to both counsel for your briefing and for your arguments today. The case will stand submitted, and we will issue an opinion in due course. Thanks again. We appreciate your work today. As you are packing up, if counsel for the next case is present, if you could just sort of be on deck to set up, that'd be great. Y'all don't want to stay for the second one? Oh my gosh, we're all going to be so offended. We bored you or something? You're like, oh, I've seen it all now. I don't need to watch anymore. We get it. I didn't realize they were all going. Like, wait, where are you going? All right, good afternoon, everyone. I hope I've given enough time for you to set up. We are calling our second case on this afternoon's docket, and that is Perez versus by the Rockies, and that's case number 2022CA1791. And council, I think, well, I'll just go over it again real quick. Remember that you're being recorded, and so if there's any information that is sensitive or you want to keep out of the public realm, please be mindful that everything is live streamed and recorded, so use initials or non-identifying information. You have 15 minutes to argue your positions, and for the appellant, if you would like to reserve rebuttal time, that's on you to keep an eye on the clock and say, I'm going to sit down and reserve my time for rebuttal. The lights indicate your green, yellow, and red. Yellow is 5 minutes, and red is your time is up. There is a toggle switch on the podium if you need to raise or lower it. It's on the lower, just under the lip there on the lower right side. And if there are no questions, please, when you're ready, counsel for appellant.
Good afternoon, Your Honors. Brian Gonzalez, and with me is Alex Hood on behalf of the appellant. The premise of defendant Appley's argument here is that the General Assembly, through multiple iterations of the Minimum Wage Act over many, many years, just keeps forgetting to put in and explicitly tie the statute of limitations to the wage claim act. Or that even stranger, that they're somehow just being coy about it and they expect trial courts and this court to just figure that out, divine that intent from literally nothing. In fact, what the General Assembly did here is they explicitly limited the statute of limitations in the Wage Claim Act to that article. It specifically says that it only applies to claims brought pursuant to Article 4, and of course the Minimum Wage Act is in Article 6. Therefore, this court should do what numerous Colorado courts have already done when there's no SOL or statute of limitations in a statute. They should turn to the general limitation statute. And in particular, in this case, it's our position that the 6-year statute of limitations applies because it applies to any case in which the parties are seeking a determinable amount of money due, and that's exactly what we have here. We have a very easily calculable amount of damages that are owed, minimum wages for missed rest breaks.
Counsel, is 102(1)(I) at issue here?
Your Honor, that was it was raised. You're referring to the 2-year limitation
Yeah.
period raised just recently in supplemental authority.
Right.
Appley's consistent position from the trial court on through has been that it isn't at issue because the statute of limitations is found in the Wage Claim Act, not the general limitation statute. So by filing that supplemental authority, they've effectively sort of undermined their entire argument. That being said, they've raised the issue, and I think our position would be it's something that if the Court of Appeals feels comfortable addressing, that we would like to see addressed, rather than going back down, having to come back up again on that issue. We don't believe it applies under the rules of construction, and I'm happy to address that in a little more detail if you'd like. So first of all, again, it's a plain language argument. The 2-year statute of limitations applies only when there's no other period of limitation at issue. It's a catch-all.
Right.
And here, there clearly is another limitations period that applies. The Minimum Wage Act claim for unpaid rest breaks, for the minimum wages arising out of unpaid rest breaks, is for a determinable amount of money due. So we don't think the court needs to go any further than that because it's plain language, because the 2-year catch-all only applies when there's no other limitations period, and because here there is another limitations period, we don't think it applies. But even assuming, just for the sake of argument, that we were to, that the court were to see some ambiguity here, then you just turn to the rules of construction that always apply. First of all, in the minimum wage context, we think this is the overriding concern. The General Assembly has been clear that it needs to be interpreted to favor employees, and obviously a longer limitations period favors employees. But then when you turn to even the common law rules of construction, obviously a longer statute of limitations is favored over a shorter one. 6 years is favored over 2. And the more specific of 2 limitations periods is favored. And here again, we believe the 6-year limitations period for a specific determinable amount of money due is more specific than the 2-year catch-all limitations period that just applies when nothing else applies. We believe the third rule, which is which statute is later enacted, is a wash here. I think from what we can tell, they were both enacted at the same time in 1986. So.
Counsel, unless you wanted to, if you had more to answer that question, please do. Otherwise,
I think that's it, Your Honor. I don't know if you would like a little argument, additional argument with the Wage Claim Act statute of limitations. But.
Well, I'm interested in how this duty, administrative, how the regulations that have this duty to keep records. How does that? What's the interplay from your perspective on, on where does that play in at all, if at all?
So the way the Wage Claim Act the Minimum Wage Act works, there's a statute promulgated by the General Assembly, and that at CRS 86118 is where you find the private cause of action. It's been there for quite some time, hasn't changed, and there's no explicit statute of limitations, as this court has found in Pilmenstein. Separately and apart from that, the Colorado Department of Labor has been granted authority under, I believe the Wage Claim Act actually creates that authority to promulgate certain regulations, determine what the proper minimum wage is, how overtime should work, breaks, et cetera. And also, and most critically here, to establish an administrative process as an alternative to the General Assembly's private cause of action. And that's what they've done here, is they have put together an administrative process. I think their authority is limited to.
So part of those regulations include like a duty to keep records for a certain period of time, and that certain period of time does not appear in the minimum wage statute or the Wage Claim Act.
Right.
And so, what impact? What do we do with that? Is it indicative of something? Is it just? Can it be different than a statute? What bearing does it have on our analysis?
I mean, first and foremost, I don't know that it would have any, because I don't think the Colorado Department of Labor has the authority to sort of regulate what the General Assembly has done. And that would effectively be narrowing the private cause of action under the Minimum Wage Act. What you see happening there is the Colorado Department of Labor has sort of circumscribed jurisdiction. I think their claims can only cover $7,500, something like that. And they have limited their administrative claim to a 2 or 3 year period. And in keeping with that, have imposed record-keeping obligations for 3 years as well.
But why would it make sense that an employee that chooses to follow the administrative route would only have that limited time, and somebody that goes to court has more time? Like, that doesn't make sense.
Well, I mean, for one thing, the jurisdiction of the Colorado Department of Labor is limited to, I think, $7,500, so it's only smaller claims, et cetera. Which might, and it also might be sort of the Department of Labor, I know just anecdotally, is inundated with these claims, and I'm sure they are looking to create sort of more tightly constricted bounds on the types of claims they hear, the sort of administrative claims that are raised with them. That's a separate process, though, from what the General Assembly has elected to do in their private cause of action. And I don't have I can't tell you exactly why CDLE decided to do it that way. I just know that they don't have authority to change the private cause of action in the General Assembly statute. And it's been that way for years.
But how does your reading of, applying that longer period of time, how does that jive with the Colorado Supreme Court's decision that, claims to recover wages have to be brought within a period of time of when they become due and payable, and they apply the 2 or 3 year period, and that's the Hernandez versus Raid and Minical Farms?
Well, first of all, that case only involved the Wage Claim Act. It had nothing to do with the Minimum Wage Act. And I think what gets lost in these discussions sometimes is that these are very different statutes. They cover different ground. The Wage Claim Act, I think, has its roots back in legislation passed in like 1901. It's a standard pay deduction statute. Most states have them. They govern the timing and form of payment. They put limits on what sort of deductions and garnishments can be made against wages, various other things. Separate and apart from that, sometime later, I believe in 1917, was the first sort of iterations of the Minimum Wage Act. And it's a sort of sets baseline standards for pay, overtime, minimum wages, breaks. That's basically what it covers. There's a little bit of overlap in the fact that a claim for minimum wages might be actionable under the Wage Claim Act as well as under the Minimum Wage Act, but they really address very different subject matters here. And in fact, the remedies are different. The Wage Claim Act has penalties that apply, whereas the Minimum Wage Act does not. So the fact that there's sort of this small overlap doesn't mean that the General Assembly intended to wholesale adopt the distinct statute of limitations from the Wage Claim Act into the Minimum Wage Act. In fact, there's no indication that they intended to do that. And I'd actually go further and say, you know, the General Assembly here has explicitly limited that statute of limitations to Article 4 claims. So the Hernandez case dealt only with the Wage Claim Act, and it accepted the proposition that a 2 or 3 year limitation statute applies to Wage Claim Act claims. That was not disputed. All it was looking at was—
But whether you're making a wage claim act or saying, you know, I didn't get the minimum wage that I was entitled to, you still have to have a period from which it begins to accrue. So it just seems to me that it would be inconsistent to then try to apply a 6-year limitations period. If you're looking back to, you know, when was I supposed to be paid this money? And, you know, you've waited 5 years and you were supposed to bring it within 2 or 3 years of its accrual.
Well, the accrual issue, I wouldn't dispute that even under the 6-year limitations statute, the accrual date for the claim would arise, as Hernandez found, when the pay was withheld wrongfully, right?
Okay.
All we're saying is for that subset of unpaid wages that's covered by the Minimum Wage Act, you can look back, as long as it's a determinable amount of money due, you can look back 6 years. Whereas the broad spectrum of issues covered by the Wage Claim Act, you can only look back 3 years. But again, they're very different statutes. They cover different things. And Wage Claim Act covers all sorts of compensation. It covers unpaid commissions. It covers vacation days. It covers pay deductions. It covers tips. It covers a number of different things that just are not addressed in the Minimum Wage Act. Conversely, the Minimum Wage Act covers things that aren't covered in the Wage Claim Act. So it's really not inconsistent for the General Assembly to have made the decision that 2 different statutes can be different in their remedies in the form of their rights. Again, Wage Claim Act has penalties associated with its cause of action. Minimum Wage Act does not. If you accept that, which is clear from the text, why can't the Minimum Wage Act have a little longer statute of limitations than the Wage Claim Act? They're not the same statute.
The Wage Claim Act applies to non-hourly wage earners?
It applies to everybody in Colorado. Basically, whatever your job is, if you don't get your last paycheck, for example, you have a cause of action under the Wage Claim Act to recover that. What it doesn't do is establish any sort of baseline standards for minimum wages over time. That comes from the Minimum Wage Act.
And that minimum wage, the Minimum Wage Act, to me, it allows sort of investigation and what's like the proper conditions of employment and what is an appropriate living wage and things like that for the sort of health and welfare of citizens of Colorado. Is that a distinct distinguisher between the 2 acts?
Absolutely. I mean, again, the Minimum Wage Act is setting certain baseline pay standards, the minimum amount you can be paid, basically. Wage Claim Act is just giving you a right to, well, it covers a lot of things. I mean, it says how your pay has to be paid. It covers when you leave employment, how soon you have to receive your final paycheck. It covers whether you didn't get commissions or salary, all kinds of things. But part of that is, you know, you can potentially cover your minimum wages under that as well, but they're very different statutes. And if your honors don't have any further questions, I'd like to reserve a little time. Thank you.
Thanks. Counsel for Appellee, when you are ready, please proceed.
Thank you, Your Honors. May it please the court. I want to clarify some misstatements by appellant's counsel. I'm not aware of any limitation to the monetary amount that the Department of Labor can consider in its administrative process. That was amended many years ago to remove the $7,500 cap. So I don't have that precise date and amendment at hand, but I do want to call that out. The other thing I want to say is that there's already precedent here from this court allowing us to harmonize the Minimum Wage Act with the Wage Claim Act with respect to when a claim accrues. And that authority is in Pemmelstein. It's Pemmelstein v. Wallace. And in that case, it addressed the same issue as we have here, which is a denied rest break claim where they were seeking payment under the Minimum Wage Act. And in that case, this court found that although Section 8-6-118 of the Minimum Wage Act, which is a statute at issue here, provides that an employee has a private right of action, the Minimum Wage Act does not specify when a minimum wage employee must be paid the minimum wage. And so this court then looked to the Wage Claim Act under Section 122, which is, again, the statute that's at issue here, which is the limitations of actions statute. And applying the limitations of action statute from the Wage Claim Act, this court found that the minimum wage claim for unpaid rest breaks accrued when the payment wasn't made during the next pay period after the meal break, after the rest break was missed. And so applying Section 122 of the Wage Claim Act under the limitations of actions to determine when a minimum wage claim accrues for missed rest breaks, that's what this court did to harmonize the statute. So this isn't some crazy idea that we're coming up with. There is precedent for it.
Well, that case didn't address the statute of limitations. And the
I was gonna say
majority
that.
specifically says, we express no opinion as to what the appropriate statute of limitations would be under that claim. That
Yes.
case dealt with whether even there was a private cause of action that was available to this plaintiff.
Yes, Your Honor. And I was going to acknowledge that court, you expressly said in that opinion that you were not making an opinion as to what statute of limitations apply. I use it to illustrate that there is precedent for harmonizing these two statutes together in terms of when a claim accrues. As Judge Fox had asked earlier, how do you determine when a claim accrues under the Minimum Wage Act? Well, this court has decided, and cert was denied by the Supreme Court on this issue, that you look at the Wage Claim Act. And carrying that over one more step further, in Hernandez, the case that Judge Fox referred to earlier, the Supreme Court found that claims accruing under Section 122 of the Wage Claim Act are subject to a 2 or 3 year statute of limitations. And all of that is consistent with every hint of intention expressed by the General Assembly.
So counsel, let me before we get further into this harmonizing concept, for me, and you can tell me where you disagree, I don't understand that we look to tools of statutory construction like harmonizing and sort of secondary sources when the plain language doesn't have like ambiguity within it. And so when I read the statute, the section that we're talking about, 8-6, right? Article 6 is the Minimum Wage Act. And your argument is that, well, look at the section before it, or two sections before it, in Article 4, and that imposes a 2 or 3 year limitation. And when I read that limitation, how do we read around the word like where they specify the 2 or 3 years applies to this article as opposed to this title?
Thank you. So in looking at the plain language and construing the plain meaning of a statute, harmonizing is part of that. The Supreme Court has given us several instructions on how to determine what the plain meaning of a statute is. One of them is to read the statute in context of the statute itself, plus the larger statutory scheme. And this court has stated that the Colorado Wage Claim Act, the Minimum Wage Act, and the wage orders, now called comps, are all part of the foundational laws of wages for workers in the state of Colorado. So we certainly have a recognized statutory scheme here. So harmonizing is not statutory construction necessarily. The Supreme Court has said you have to look at these things as a whole when you're determining the plain meaning, with the paramount intent of finding out determining what is the General Assembly's intent in this statute at issue. And here we've got, in 1986, the General Assembly adding the statute of limitations to the Colorado Wage Claim Act, and in doing so, saying that they want to make Colorado's wage laws consistent with federal law. And the statement was made generally why they only added it to Article 4 and not Article 6,
Well, my
I don't
trouble,
know.
counsel, is it's not just like, oh, gee, they added it to Article 4. They specified this article. I mean, we have to assume that they used the words they meant to use. This, meaning this, and this article, not this title. And they've expressed this title in other statutory schemes. Like, how do we just overlook that? You know, and then when I look to the next section 5, right, Article 5, the Wage Equality Act, like fair wages for fair labor, right? You know, they specify a statute of limitations there also, which is somewhat slightly different than in Article 4. So for me, when they mean to intend to impose a statute of limitations, they say so. So like, I'm having trouble with like, let's jump ahead to, well, we have to harmonize and look at the, legislative history and what the federal district courts have said. And so help me bridge that gap.
So I'll say that I disagree with counsel and my friend that the Minimum Wage Act and the Colorado Wage Claim Act are some completely different laws. In my opinion, not in my opinion, the case law says the Minimum Wage Act sets the minimum wages that must be paid to workers. The Colorado Wage Claim Act sets forth the rules on how you pay them, when you pay them. And so when you have a minimum wage claim, there is a private right of action expressed under the Minimum Wage Act. But as this court has stated, you would look to the Wage Claim Act to determine when that claim accrued, which is the language used in Pilmelstein, understanding there was a non-decision on the statute of limitations. But you look to the Colorado Wage Claim Act to determine when does that wage accrue? How is it supposed to be paid? And so that is how I link these together. I see a claim under the Minimum Wage Act, a claim for minimum wage, being the same as thou bringing a claim for wages under the Claim Act. And you see that through how the Department of Labor has issued one set of regulations to essentially rule them all, to cover both of these sets of laws. And again, as you discussed earlier, the only record-keeping requirement among any of these laws is 3 years, which is also consistent with a statute of limitations of 2 or 3 years. And I will say the General Assembly did amend the Colorado Wage Claim Act to add a 3-year record-keeping requirement in 2015, which has also been implemented into the regulations, that there's a 3-year record-keeping requirement. And that record-keeping requirement in the regulation applies to any wage claim, any wage records that would go to a wage claim, which I think is strong evidence of a 2 to 3 year intention of a statute of limitations.
So where was the 2015 enactment? Where can I find that?
It's in our briefing.
Okay.
We did, sorry, Your Honor, we did list the citation for that 2015 amendment in our briefing. Also, it was addressed in the Hernandez case. The Supreme Court also looked to that 3-year record-keeping requirement as being strong evidence of a 3-year statute of limitations.
Was that the Supreme Court case, or that was one of the federal district court?
Hernandez. That was Hernandez, the Supreme Court. Yeah, so and the reasoning for the Hernandez court put forth for the accrual being 2 or 3 years, depending on willfulness, is this public policy notion of not wanting to litigate stale claims.
Well, counsel, so when we go again back to that Wage Equity Act, that's being amended as of January to allow a look back to 6 years. So how do you reconcile that? I mean, again, it's like, doesn't it seem that it's section or, act, article by article? Because if Hernandez is saying, gee, all of this should be streamlined and it should be 3 years, I read that as talking about when the claim accrues, right? They were like, well, when you first knew about it, as opposed to it's a rolling accrual. So I'm not placing the same weight necessarily as you are about like, gee, that was more about what's the statute of limitations as opposed to when does it accrue. And the Supreme Court said it accrues every time your pay is due and not paid. So it's a rolling accrual date, not necessarily a reflection of the statute of limitation applies across the board. But when I look at the Wage Equality Act, now they're changing that in January so that the look back it goes from 3 years to 6 years. So again, we would have this inconsistency with the regulations and the statute come January.
So we'll say the Pay Equality Act is, so we've got the Wage Claim Act and the Minimum Wage Act, which have consistently been recognized as the foundational laws about payment of wages to workers. And then sandwiched in between, you've got this Pay Equality Act. And the Pay Equality Act has to do with fair pay, non-discriminatory pay. It has a different angle.
Well, the damages are, again, include pay me what you owed me. You owed me this, you didn't pay it to me, and so it's still a recovery for wages. I agree with you that they're different in terms of their purpose. And so what I'm getting to is that when you then flip to the next section, the Minimum Wage Act, the legislative, what's it called, like the statement of purpose at the beginning, it talks about the welfare of the state of Colorado. And the Minimum Wage Act is there to preserve the welfare of the state of Colorado, and it demands protection for workers from conditions of labor that have a pernicious effect on their health and their morals. And so this pernicious effect, to me, is something different than what are your deductions, where is the retirement withdrawal, when is my payment due upon termination, rather a fundamental foundation of how we're going to treat people properly. And I think of minimum wage as typically applying to hourly workers, like your agricultural workers, which are in the statute, food service workers. I mean, how if somebody doesn't get paid on the day they don't get their rest break, they're not going to file a claim for $1.12. I mean, doesn't it seem to 6 years would make more sense in order for the accrual of the claim itself to have some value?
So what the Assembly did express, as I said, in 1986, is that they wanted the Colorado wage laws to be consistent with the Fair Labor Standards Act. The Fair Labor Standards Act, like the Minimum Wage Act, regulates minimum wages and overtime. That is the focus of the Fair Labor Standards Act. And so I believe it would be consistent with the legislative intent, despite the Minimum Wage Act not having an express statute contained within itself, to look to the Wage Claim Act to render that intent consistent with the Federal Labor Standards Act. I would like...
Counsel, let me ask, you filed supplemental authority that cites 1021I. You're not arguing that at all now. I don't understand.
So we actually did not take the position that we weren't arguing it. We did. So here's what I have to say about that. Thank you. So with respect to that issue, even if it could be said that the 2 to 3 year statute of limitations doesn't apply from Section 122, it doesn't mean that the 6 year statute of limitations apply. And this court can affirm on any grounds supported by the record, regardless of whether it was even considered by the district court. And so that's where we invite the court to look to the supplemental authority we submitted in Roman versus Manicava. Judge Martinez found that a wage claim is in the nature of a wage claim. It's a statutory claim. And that the 6 year statute of limitations that was advocated by the plaintiff's counsel in that case had not been applied outside of a contract claim for wages. Here, we don't have a contract claim for wages. We have a statutory claim.
Counsel, you've got like 20 seconds left,
know.
and when you said we can affirm on any grounds based, supported by the record, this was not argued before the trial court, correct?
This issue was not included in our briefing at the trial court, correct, Your Honor? So what I would say in my last 2 seconds is that this is a statutory claim that would be subject to the general statute of limitations, which is a 2-year requirement for the reasons that Judge Martinez opined in the supplemental authority we submitted. And I'm out of time.
Thank you
Thank you,
very
Your
much,
Honor.
counsel, for your arguments. I appreciate it. Thanks to both. Oh, sorry, we're not done. Look at me, I got ahead of myself. We have 1:43. I apologize sincerely.
Be unlike a lawyer not to use all his time. Right? So, one thing I would say is if the Wage Claim Act and the Minimum Wage Act are identical, why do they have 2 completely different private causes of action? Wage Claim Act allows penalties, Minimum Wage Act does not. Why can't the Minimum Wage Act have a little longer statute of limitations? I mean, they're just different causes of action.
What are the kinds of penalties that are allowed under the Minimum Wage Act that aren't under the Wage Claim Act?
There are no penalties on the Minimum Wage Act, just the
Sorry.
wages owed and attorney's fees. Wage Claim Act, in contrast, has some pretty substantial penalties that apply.
Okay.
And also, it applies to different kinds of wages that aren't covered by the Minimum Wage Act. Section 84111 is from the Wage Claim Act, and it's what establishes the right of CBLE to create an administrative process. So that administrative process is divorced from the Minimum Wage Act. And there is, our understanding is there's a $7,500 limitation. I mean, the court can easily confirm that. The Wage Claim Act was amended in 1986 to add this limitations period, 2 to 3 years. At the time, the Minimum Wage Act was in existence, and they didn't make any effort to change it then. Again, they looked at this earlier this year, and again, there was no effort by the General Assembly to change the existing precedent regarding the 6-year statute of limitations applying to the Minimum Wage Act. This is just a plain language case, Your Honors. The Wage Claim Act says its statute of limitations applies only to Article 4 claims. We're dealing with Article 6 claim here. We just don't see how it can apply. Thank you for your time.
Thank you, counsel. Now, again, I apologize for prematurely indicating, but I do appreciate your arguments and the briefing from both sides. The case will stand submitted, and we will issue an opinion in due course. And I believe that is the end of our docket this afternoon. And so our afternoon setting is in recess. Thank you.